So the topic of this session is local cooperation and implementation of mixed agreements. In the case we are studying free trade agreements. The Court of Justice of the European Union pointed out in Opinion 194 concerning the conclusion of the WTO agreements that any problems which may arise in implementation of the WTO agreement and its annexes as regards the coordination necessary to ensure unity, where the community and the member states participate jointly, not where we have a mixed agreement. So any problems which may arise cannot modify the answer to the question of competence, that being a prior issue. As the Council has pointed out, the Court says, resolution of the issue of the allocation of competence cannot depend on problems which may possibly arise in administration of the agreements. So, as we have already discussed, mixed agreements raised questions of unity in the international representation of the Union and the Member States. However, mixed agreements are the consequence of the principle of conferral. The choice between a mixed agreement or an EU-only agreement is not a function of the difficulties in the management of mixity, but of the necessity criterion of Article 216 that we have already discussed in the framework of the Court of Case. So it is difficult to consider that limits to mixed agreements stem from the duty of loyal cooperation. One is the principle of conferral, the question to know whether the Union concludes an EU-only or a mixed agreement. The other issue is unity in external representation, where the duty of loyal cooperation intervenes. So the duty of loyal cooperation limits the exercise of the Member States' reserved competence, but is not sufficient to exclude it. In other words, loyal cooperation is a principle governing the exercise of competencies and operates in the framework of the principle of conferral. Loyal cooperation is provided for in Article 4, Paragraph 3 of the Treaty of the European Union, but Article 4 refers first, in the first paragraph, to the principle of conferral, and next to the principle of sincere cooperation or loyal cooperation with the law. Of course, the duty of loyal cooperation intervenes in the management of mixity and implementation of mixed agreements, but always in the framework of the principle of conferral. So let's recall the duty of sincere cooperation, the duty of loyalty. According to Article 4, Paragraph 3 of the Treaty of the European Union, pursuant to the principle of sincere cooperation, the Union and the Member States shall, in full mutual respect, assist each other in carrying out tasks which flow from the treaties. The Member States shall take any appropriate measure, general or particular, to ensure fulfillment of the obligations arising out of the treaties or resulting from binding acts, and the Member States shall facilitate the achievement of the Union's tasks and refrain from any measure which could jeopardize the attainment of the Union's objectives. So we see several obligations. We see a procedural obligation, mutual obligation to cooperate through consultations, cooperation between the Member States and the Commission. This is a mutual obligation of procedural cooperation. We see an obligation to ensure effective implementation of the rules of EU law, including international agreements and mixed agreements. But also we see in the last subparagraph the obligation of the Member States to facilitate the achievement of the Union's task and to refrain from any measure which could jeopardize the attainment of the Union's objectives. So Article 4, Paragraph 3 applies both in the internal and the external field. But what is specific with the external field? It is exactly the objectives. As the obligation of loyal cooperation includes the obligation not to jeopardize the achievement of the objectives and to facilitate their achievement, the question is what is particular with regard to the objective. And with regard to the external action objectives, what is specific is that beyond the policy objectives, we have the objective of unity in the international representation, which does not correspond to specific competence. It means that the objective to ensure unity in international representation of the Union and the Member States implies an obligation to limit the exercise of the Member States' sovereign rights, not to deprive them from their competence. This is the principle of conferral. That's why we have a mixed agreement, but to limit the exercise of the reserved competence. The Court of Justice specifies the obligation stemming from the duty of loyal cooperation. Already in Opinion 194 concerning the WTO agreements, the Court of Justice underlined that in a field falling under shared competence of the Union and the Member States, it is essential to ensure close cooperation between the Member States and the community institutions, both in the process of negotiation and conclusion and in the fulfillment of the commitments entered into. That obligation to cooperate, the Court says it explicitly, flows from the requirement of unity in the international representation of the Union. This requirement is not codified in a specific provision. It stems from the general objective to make the Union an effective international actor. So it's the principle of effectiveness in the external action. It is not about a policy objective. It is not about a specific obligation. It is a requirement of unity stemming from the general objectives of external action beyond the policy objectives. And there, the loyal cooperation duty implies specific obligations for the Member States in the management of mixed agreements. There are several questions that can be raised. Are the Union and the Member States to be considered as a single party in international agreement, in a mixed agreement? Does the division of competencies is opposed to the third parties? We will discuss first the specific obligations stemming from the principle of loyal cooperation with regard to the Union's external action objectives. Next, we will discuss the externalization of the division of competencies in the implementation of mixed agreements in light of the principle of loyal cooperation. So first, specific obligations stemming from the principle of loyal cooperation with regard to the external action objectives, and next, the externalization of the division of competencies in light of the principle of loyal cooperation, where we see a constitutional dimension of loyalty, of the loyalty obligation, the obligation to ensure the autonomy, the specific characteristics of the EU legal order. So first of all, let's see what kind of obligations, in the case law of the Court of Justice, stem from the duty of loyal cooperation with regard to the external action objectives. The scope of the principle of sincere cooperation or loyal cooperation is apparent in cases where the Court of Justice recognizes an autonomous content to this principle. It means beyond the cases where loyal cooperation finds specific expression, no? As for example, the obligation to implement a mixed agreement. It is first of all the obligation stemming from Article 216. International agreements are binding for Member States. There is loyal cooperation there, but finds a specific expression. Primacy, legality, obligation to apply EU law. Another specific expression, the obligation not to impede, we discussed it yesterday, the ratification of the mixed agreement for reasons which are related to the exclusive competence provisions. There we have the specific principle of conferral, which includes loyal cooperation, but there is no autonomous content to loyal cooperation. So we will see the cases where the Court of Justice recognizes an autonomous, a proper content to the principle of loyal cooperation with regard to the external action objectives. So this kind of specific obligations refer to and limit the exercise of the Member States' reserved competence in view of the objective of unity in the international representation of the Union. So as we already mentioned, this is an ultimate, a general objective which does not correspond to a policy objective. And there we see how the duty of loyal cooperation may go beyond the principle of confer, not in order to alter the division of competences, but in order to limit the exercise of the reserved competence of the member states in the external field in view of this objective to ensure unity. So, which are the specific obligations stemming from loyal cooperation? There is first a procedural and reciprocal obligation of unity. To give an example in some more recent case law beyond the opinion on WTO agreements, the Court of Justice underlined that both the Union and the Member States should be involved in the negotiations of the mixed agreement by cooperating closely in all stages of the process in order to ensure the unity. It means also in the management of mixity. It means where the member states have to present a common position, where they have to divide with the union the exercise of voting rights, the exercise of taking part to the debate, who will present a position. In all these cases where the union and the member states have to decide who will talk with regard to a specific issue in the context of mixed agreement, the first obligation is to cooperate in order to decide what kind of provision is about, of norm is about, which field of competence is concerned, who will present the position, and what kind of position. So, who will exercise the voting rights? All these issues are governed by the principle of procedural cooperation between the member states and the Commission. And of course, the exercise of voting rights by the Council or by the member states, but it supposes a duty of procedural cooperation and consultation. Another specific obligation is that to refrain from autonomous action in the field of shared competence in the framework of the mixed agreement where there is no previous cooperation with the Commission. A well-known example in this case is the ruling Commission versus Sweden, where we are in the context of a mixed agreement in the environmental field, and Sweden had presented an autonomous position on its own in a field always falling under its shared competence, but the Court of Justice considered in an infringement procedure initiated by the Commission that Sweden had infringed the duty of loyal cooperation. As the Court pointed out, such a situation, it means where a member state expresses in an international context an autonomous position without having coordinated with the Union. Such a situation is likely to compromise the principle of unity in the international representation of the Union and its member states and weaken their negotiating power with regard to the other parties of the Convention. So even if we are in a field falling under shared competence, there is a duty to coordinate, to cooperate, and not to express an autonomous national position. Another specific obligation is stemming from the duty of loyal cooperation is with regard to the implementation of a mixed agreement. The question is to know the obligation to implement a mixed agreement as an EU law obligation. Does it concern only the provisions falling under the competence that the Union has exercised, exclusive competence, or it concerns the mixed agreement as a whole? The Court of Justice has considered that the obligation to implement, to ensure implementation of a mixed agreement is an obligation which concerns, is an EU law obligation which concerns the mixed agreement as a whole, and that because of the duty of loyal cooperation. It is interesting to see what the Court held in an early case, Kupferberg. According to the Court of Justice, by implementing an international agreement, member states fulfill an obligation towards the Union, bearing international responsibility in case of violation of the provisions of the agreement. The Court makes the link between the obligation of the member states to ensure implementation of an agreement and the international responsibility of the Union with regard to the agreement. In other words, the member states have the obligation of loyalty to ensure that the Union will not bear international responsibility because of the infringement of the agreement. And because, as we will see, responsibility is not necessarily divided, and because a union bears responsibility, may bear responsibility for a mixed agreement as a whole, there stands the duty of loyal cooperation for the member states to ensure that the union fulfills its obligations. As a consequence, having considered that a mixed agreement in its entirety is an EU law obligation for the member states, the Court of Justice held that it has interpretative competence for the mixed agreement as a whole in order to decide which provisions fall under which sphere of competence. This is an interpretative competence of the Court of Justice for the whole, for the entirety of the mixed agreement. This is the position of the Court in cases like Demirel, Parfum Christian Dior, case Merck, where the Court distinguished between its interpretative jurisdiction for the whole mixed agreement and the division of competences in the implementation of specific provisions in order to assess the direct effect of the provision of the mixed agreement. First, the Court of Justice has to decide whether the specific provision falls under exclusive EU competence or under shared competence. If it is exclusive EU competence, it will be for the union judge to interpret it and to assess direct effect. If it is shared competence, and that is a question that the Court of Justice decides, if it is shared competence, then it is for the national judge to assess the direct effect and those to implement in the specific case the provision of the mixed agreement. So the mixed agreement as a whole is an act of the institutions with regard to the interpretative competence of the Court of Justice. Also in the framework of an action for infringement. We have two examples, Commission versus Ireland, Commission versus France. It's the Berne Convention case and the Étang de Berre case. In the Commission versus Ireland case, Ireland was accused of breaching an obligation deriving from a mixed agreement, the EA agreement, to accede to the Berne Convention related to intellectual property rights. So there was an obligation falling under the member states' competence to accede to the Berne Convention. Ireland infringed this competence, but this obligation stemmed from a mixed agreement. So the Court of Justice considered that there is an EU law obligation to implement provisions of a mixed agreement, even those stemming from the sphere of member states' competence, falling under the sphere of member states' competence. So an infringement procedure is envisaged for the mixed agreement in its entirety. There is an EU law obligation for the member states to implement provisions falling under exclusive EU competence and under shared competence, under their reserved competence. And all this situation because member states have the obligation of loyalty to ensure that the union will not be held responsible for the violation of the mixed agreement in the international field. Another case is Commission versus Ireland, is the Mox Plant case in the framework of the United Nations Convention for the Law of the Sea, where Ireland has been considered as having violated the duty of loyal cooperation because it addressed a claim against the United Kingdom before an arbitral tribunal, while it is a question in the framework of the mixed agreement, which is to be seen as a whole as an EU law act. So the jurisdiction to discuss this litigation issue is for the Court of Justice of the Union. However, one should underline that while a mixed agreement is considered as a whole as an EU law obligation, the division of competence is to be respected in the implementation of a mixed agreement. And so we have the next question. Is there a loyalty obligation to consider the mixed agreement as a source of EU law because of the international responsibility and the duty of loyalty to avoid that the union is held responsible, or it is the international responsibility of the union for the agreement as a whole, which stems from the duty of loyalty to keep the division of competencies as an internal EU law issue. So we have two dimensions of the duty of loyalty. A dimension with regard to the unity of the external presentation and the efficiency of the union's action. If the union is to be held responsible for a mixed agreement as a whole, there is a duty of loyalty to ensure this international obligation of the union. But at the same time, why the union is to be considered as responsible for the mixed agreement as a whole? There is a question of the externalization of the division of competence. Why the union not to be considered as responsible only for the EU competence provisions? Why is to be considered responsible for a mixed agreement as a whole? Is it because there is a duty of loyalty not to externalize the division of competence? And why not to externalize? Because there is a duty of loyalty to preserve specific characteristics of the union legal order which contain the division of competences. So we have now the second question, the external dimension of the division of competencies in the implementation of mixed agreements in light of the principle of loyal cooperation. And there we have the constitutional dimension of loyalty, loyalty with regard to the EU legal order, with regard to its autonomy. The more specific question is the context. In this context are, first, is the division of competencies an EU law question? And second, what about the allocation of international responsibility? Is the division of competencies an EU law question? Always in the context of a mixed agreement, because it is there where we have the question of the division of competencies. Who is to be held responsible and why? If we have an infringement of a provision falling under union exclusive competence, can a member state be held internationally responsible, or the opposite? If we have the infringement of a member state competence provision of the mixed agreement, is the member state to be held responsible? And what about if the member state applied an EU law regulation or directive? So we have these issues of division of international responsibility, and the question is, can the division of competencies be opposed to the third parties? What about the text of mixed agreements? The starting point is to say that the division of competencies is an internal EU law issue. And because of the obligation to preserve the autonomy of the EU legal order, a dispute settlement body or third states should not interfere with the division of competence. So it should stay an internal EU law issue, and it will be up to the union and the member states to decide who will be the respondent party in case of a litigation. However, if we see mixed agreements, we may have two elements which express an externalization of the division of competence. We may have a declaration of competencies, and we may have a disconnection clause. What is the declaration of competencies? Declaration of competencies are instruments which form part of a mixed agreement, mixed multilateral in principle agreements, because in bilateral agreements we have the reference to the contracting parties, and usually we have the reference according to which is to be considered as a party the union or its member states following the division of competencies. But in multilateral mixed agreements, it is a used to have declaration of competencies. So declarations of competence are instruments inserted into mixed agreements and are usually adopted as an annex to the ratifying decision of the Council and filled with the agreement at the ratification or accession stage. And these declarations refer to the internal acts of the Union, directives or regulations adopted in the field covered by the agreement. And so it is a means to show to the third parties, contracting parties, who is competent for which provisions of the agreement. However, declaration of competence are not clear, because what about if a declaration refers to a harmonization directive? It is still a field covered by union law, but not with a field falling under exclusive union competence. The Kotick decision we discussed yesterday, there was a declaration of competence in the convention about rail transport, but it was not clear if it was exclusive competence of the union or shared competence, because we have had then a harmonization directive. Another problem is that the division of competencies is an issue which changes, we have an evolution of the division of competence to the extent to which the union intervenes in the internal field. So the declaration of competence is to be adapted. For all these difficulties, it is also difficult to consider that the declaration of competence is the right instrument in order to allocate responsibility according to the division of competences. For instance, the United Nations Convention on the Law of the Sea contains a declaration of competence and provides that the respondent party, the responsibility is allocated according to the declaration of competence. However, the United Nations Convention on the Law of the Sea provides also for joint responsibility of the Union and the Member States, where the Union and the Member States, the entire party they form, cannot decide on the respondent party and who bears responsibility. So there is also this requirement to ensure effective implementation. So if it is not evident, if it is not easy to allocate responsibility according to the division of competences, then in case of mixed agreements, there is a joint responsibility of the Union and the Member States. So the declaration of competence is not it's an instrument that may show an externalization of the division of competence, but it is not sufficient in order to allocate responsibility according to the division of competence. In other words, the division of competence may remain an internal EU law issue. What about disconnection clauses? A disconnection clause is a clause also inserted in a mixed multilateral agreement, according to which, in their mutual relations, the member states are to apply EU rules, are not to apply rules of the convention. What does it mean, this clause? It is an expression of the complementary participation of the Union and member states in a mixed agreement, saying that mixed agreement creates obligation between, on the one hand, the Union and the member states, and on the other hand, the third parties, and not between the member states of the Union. So it is an expression of the mechanism of mixity from an EU law point of view. But of course, it is not sufficient in order to externalize the division of competences. As a consequence, division of competences, declaration of competences, and disconnection clauses are not sufficient in order to allocate international responsibility. So the question is, can a dispute settlement body or the third states or the investors, in case of investment agreements, intervene in the determination of the allocation of responsibility and address the claim to the Union or the member states without having regard to the division of competences? So beyond the free trade agreements where we have a specific regulation, which is the expression of the internalization of the division of competencies, beyond this specific case that we will see now, in general, in mixed agreements, whether we have a declaration of competencies or not, the result is to ensure, it is necessary to ensure effective implementation, and those, finally, there is always a joint responsibility of the Union and the member states, because the division of competence has to remain an internal EU law issue. But let's see more precisely the question with regard to investment treaties. In the new generation of free trade agreements, we have specific provisions concerning the allocation of responsibility and dispute settlement. We don't have a declaration of competencies. There is no need because, as it has already been discussed, at first sight, investment treaties and new generation investment agreements fall under exclusive competence of the Union. It is only some provisions, non-direct investment protection provisions, which fall under shared competence, and the dispute settlement institutional provision. But we don't have a declaration of competence. However, we have provisions which concern the dispute settlement with regard to the division of competencies of the member state, or with regard to the respondent party. It means the question to know who is responsible in case of a damage occurred to the investor. So if we take Article 8, paragraph 21 of the CETA, according to this provision, if the dispute cannot be settled through consultations, the request concerns an alleged breach of the agreement with the European Union or a member state. The investor intends to submit a claim. So, to whom the investor will address. The investor shall deliver to the European Union a notice requesting the determination of the respondent. It is not a question of competencies. It is rather a question who is the respondent, to who is attributed the act which caused damage. The notice under paragraph 1 shall identify the measures in respect to which the investor intends to submit a claim. The European Union shall, after having made the determination, inform the investor as to whether it is the European Union or the member states that will be the respondent party. So this provision of the CETA does not concern international responsibility, but the question is who will be the respondent party in case of dispute. If the Union does not precise who is the respondent party, according to the same provision of CETA, in the event that the investor has not been informed of the determination within 50 days of delivering its notice, the provision of this free trade agreement gives some possible solutions. If the measures identified in the notice are exclusively measures of the member state of the Union, the member state shall be respondent. If the measures identified in the notice include measures of the European Union, the Union shall be the respondent. The investor, according to the same provision, may submit a claim on the basis of the determination made pursuant to paragraph 3. And if no such determination is made by the Union, on the basis of the rules of paragraph 4. If it is an action of the member state is the respondent. If it is an action of the Union is the respondent. And paragraph 6 of this provision of CETA underlines that this definition of the respondent party is not to be contested by the arbitral tribunal, not by the investor, nor by the investor. The tribunal shall be bound by the determination made pursuant to these provisions. However, the question is, if the Union does not define the respondent party, then we have these rules to define the respondent party, but there is no reference to the competence, nor to the international responsibility. So the question is that here we have a possibility that the investor who claims damages intervenes in the allocation of responsibility, because the definition will be made also according to the international rules of responsibility. According to the draft articles on responsibility of international organizations stemming from the International Law Commission of the United Nations. We have, however, this paragraph 6, which preserves the internalization of the division of competences, because the investor cannot deny the determination of the respondent party following the provisions which are defined in the CETA agreement. However, there is still the risk that there is no exact correspondence between international responsibility, competencies, and still the investor will apply a provision of an international agreement. It means that there is a kind of externalization of the division of competence. That is why the Union adopted an internal act, the financial regulation, concerning the allocation of financial responsibility, which is to be distinguished from the international responsibility under international law. Financial responsibility concerns precisely the implementation of investment treaties. And the question is, what is a financial responsibility, which is dissociated from international responsibility? Financial responsibility means an obligation to pay a sum of money awarded by an arbitration tribunal or agreed as part of a settlement, including the costs arising from the arbitration. So, for the allocation of the financial responsibility, we have the rules stemming from the financial regulation of the Union, which distinguishes financial responsibility from international responsibility. Already in Recital 3, according to the regulation of 2014, international responsibility follows the division of competencies and remains, in principle, an EU law issue. As a consequence, the Union will be, in principle, responsible for defending any claims concerning violation of rules falling under its exclusive competence, and the member states will be responsible for the violation of rules falling under shared competence, but this correspondence between competence and responsibility is not to be defined by an external body, nor by a third party. However, for the allocation of financial responsibility, who will pay? The decisive element is from whom stems the act that has caused the damage, and so there are specific rules in the regulation. We can read the regulation, its provisions, to see how financial responsibility is allocated, but there are some principles, and then there are many derogations. The regulation refers in several times, notwithstanding to derogations. So the principle is that the following criteria will be applied. The Union shall bear financial responsibility arising from treatment afforded by the institutions of the Union. So to whom stems the act having caused the damage to the investor. The member state concerns shall bear the financial responsibility arising from treatment afforded by that member state. By way of exception, already we have an exception. The Union shall bear the financial responsibility arising from treatment afforded by member state where such treatment was required by Union law, which is a case not provided for in the provision we discussed of the CETA. CETA says that the respondent party will be the Union for an act afforded by the Union, the member state for an act afforded by the member state, regardless of the fact that the member state applied EU law. So this specific requirement, we have it because it is an internal regulation of the Union and allocates financial responsibility according to the internal division of competencies and obligation of the member states to implement EU law. So as already said, the regulation provides for notwithstanding from specific cases. Maybe it is too precise to go in depth and we don't have time, but it is interesting to underline finally Article 6 of the regulation, which refers precisely to the principle of loyal cooperation and consultations between the Commission and the Member States. So we have the rules allocating financial responsibility. Many derogations of these rules, which concern the cases before the dispute settlement body of WTO, on specific cases. And we have Article 6, which provides that in any case, what is important is to ensure cooperation between the Member States and the Commission. They shall take all necessary steps to defend and protect the interests of the Union and of the Member States concerned. And this obligation stems from the duty of loyal cooperation, a specific reference to Article 4, paragraph 3, so to the duty of loyal cooperation. In other words, we come again back to the duty of loyal cooperation, which shows its constitutional dimension here, the internalization of the division of competence in case of dispute is linked to the obligation to preserve specific characteristics of the EU legal order, which is the division of competence, and from that stems the obligation of the member states to cooperate in order to ensure that there will be no external interference in the determination and the allocation of international responsibility and the determination of the respondent party.